Все, дуже дякую. Да. Давайте тоді я буду сьогодні говорити українською, незважаючи на те, що я дуже рада
Okay, I'm going to be
вітати
speaking Ukrainian,
експертів,
but
як і
I'm
національних
still
на цій
so
панелі. Мені
grateful
була
to all the international and national experts. This is a great honor for me to be the moderator of one of my favorite topics, which is mediation in administrative cases.
На моє особисте переконання,
I'm
ця
deeply convinced
тема
this topic is really interesting and important for mediation developments in Ukraine, just because since our government agencies and courts are ready to use mediation in such disputes as those that pertain to administrative cases, I think we're going to get a strong push towards the development of mediation in Ukraine. Now, natural persons and mediators themselves and lawyers and legal professionals are interested in mediation, but we do not yet have a large-scale happening when mediation is not only recognized legislatively, but it's going to be perceived as an efficient procedure and pretty much exercised and referred to by government agencies. It is my pleasure to be opening this panel today. And hopefully today our speakers and myself will be able to help you dive into the world of those who support mediation in administrative disputes. Let me hand the floor over to our honorable speakers. This is my pleasure to give the floor to Karim Salema. Mr. Karim and I met together when we were discussing new recommendations. He's a state councilor, administrative judge at the Egyptian Council of State. And we had consultations with Mr. Karim. Then I was writing an academic article about this, providing explanations and prospects for Ukraine. Karim, please, the floor is yours.
Good morning, Alina. Good morning, everyone. Do you hear me well? Okay, perfect. Good morning, everyone. Thank you, Alina, for this introduction. It's a great pleasure to be here with you today. It's such a passionate topic. Actually, I'm completing a PhD in administrative mediation, and it's for me one of the most. I will not be talking about my thesis today. Okay, we'll be talking about mediation, administrative mediation in Europe and in France. But let me extend my gratitude to all the organizers of this excellent and well-organized forum, and all the distinguished speakers of this panel and the other panels of the forum. Okay, let me put my presentation in sharing. Okay. Is it okay? Do you see my presentation? The PowerPoint is shared. Is it okay? Alina,
yeah, it's working. You can continue.
Yeah, it is okay.
Yeah, okay. So, as we all know, mediation in administrative disputes is relatively new in Europe compared to its application in fields like family and civil disputes. This raises important questions. How is mediation in administrative disputes being practiced today across Europe? What challenges are hindering its development? Are there any best practices worth sharing? To answer these questions, this presentation will be organized into two sections. First, I will present the results of a study I contributed to for the European Commission for the Efficiency of Justice, CEPEJ, which is an entity of the Council of Europe. And I'm pretty sure that Dr. Ramantz this morning has given you a very good overview on the tools developed by the CEPEJ in the field of mediation. Actually, the study examined administrative mediation practices across its member states. And then in the second section, I will briefly review France's experience in implementing mediation to resolve administrative disputes. But before we get to the results of the study conducted by the CEPEJ, let me provide you with some context. In December 2022, the CEPEJ adopted a new tool with the purpose of promoting the use of mediation in administrative matters among member states of the Council of Europe. What distinguishes this tool from other developed by the CEPEJ in the field of mediation is that it is the first tool focused exclusively on administrative mediation. To ensure the production of a comprehensive tool, we chose to take a proactive approach to understand the current state of administrative mediation practices. So we conducted some interviews with national mediation practitioners, and we also distributed comprehensive questionnaires to relevant stakeholders in all member states, so that we can gather the maximum amount of information to fill any gaps in our knowledge surrounding administrative mediation. The analysis of responses received, as well as national legal frames and relevant studies, revealed intriguing insights. First, there is a significant diversity of situations across Council of Europe member states concerning—
Are you going to be switching the slides, I'm sorry? Or this is going to be just the front page?
I'm sorry?
Are you going to be moving the slides, or this is going to be just the front page? Because
Yes,
all we can see is the front page so far.
Okay.
Sorry about that.
Thank you. No, thank you. Okay. So first, there's a significant diversity of situations across Council of Europe member states concerning mediation practices. Secondly, there are various barriers that impede the progress of mediation in administrative disputes. So concerning the first observation, the diversity of situations, it has been noticed that there is a notable disparity between member states regarding their understanding of the mediation process. And even the terminology used to describe the process also differs across member states, with terms such as mediation in France, amicable settlement in Luxembourg, conclusion of appeasement agreement in Lithuania, conciliation in Germany, etc. The practices of mediation in administrative matters are very diverse. However, they can be classified into 4 groups. The first group, comprising countries such as Andorra, Armenia, the Czech Republic, Northern Macedonia, and the Republic of Cyprus, lacks the existence of administrative mediation. Although some of these member states have provisions for mediation in civil cases, there is no legal framework for administrative mediation. The second group of member states have a legal framework for administrative mediation. However, it is rarely implemented. And this is the case in countries such as Bulgaria, Portugal, Azerbaijan, Croatia, and Ukraine. Talking about Ukraine, actually, the time we received responses from our national contacts, we had a discussion about where to categorize the Ukrainian situation. Although in Ukraine, the Ukrainian legislation, specifically the Code of Administrative Justice, allows parties to consider conciliation at any stage of proceedings. It doesn't establish a comprehensive legal framework for mediation. So it can be both in the first group and second group, but I will leave the question of classifying the Ukrainian situation to our Ukrainian colleagues. The third group is distinctive in that administrative mediation is practiced informally. So despite the absence of a legal basis, there is a practice of administrative mediation, and this is the case of the Administrative Court of Luxembourg, Although there are no official statistics on the number of such mediations, the court stated that the number of amicable settlements is roughly 10% to 15% of the registered cases annually, which is very good. The fourth and last group comprises member states where mediation in administrative matters is practiced in the light of an explicit legal basis. This group includes countries such as France, Germany, Lithuania, Latvia, Monaco, the Netherlands, Spain, Switzerland, and UK, among others. And then we noticed that within this last category, the administrative mediation practices vary greatly from one member state to another. That's why this group is divided into 3 subgroups. First, for some countries, the only available mediation is institutional, such as in Switzerland, where every region has an ombudsman known as the Bureau Cantonal de Médiation Administrative, BCMA. So natural or legal persons can contact the office of the regional administrative mediator to demand an amicable resolution of their disputes. The second subgroup comprises member states where mediation is primarily practiced within the judicial context. This is the case in countries like Germany and Spain. However, there is a key difference between these 2 cases. In Germany, for example, mediation is generally conducted by a judge known as a judge conciliator, and today there is at least one judge conciliator in every tribunal. Conversely, in Spain, the mediation process is typically conducted by mediators who are not judges. The third and final subgroup within this category is referred to as a hybrid system. In this subgroup, mediations can be conducted by institutional, out-of-court, or court-appointed third parties. This diverse range of practices can be seen in countries such as France, Lithuania, and the Netherlands. In France, for instance, administrative disputes can be resolved through different types of mediation, including jurisdictional, out-of-court, and institutional. And of course, we will delve a little bit into the French experience at the end of this presentation. Now let's move on to our second point, the barriers we observed that hinder the development of mediation administrative disputes across Council of Europe member states. Despite a general agreement among national stakeholders on the advantages of administrative mediation, including improved citizen administration relations, reduced court appeals, more efficient and cost-effective dispute resolution, and a confidential approach to resolving conflicts, the actual use of mediation in administrative matters remains low, as reflected by limited statistics. So what are these barriers impeding the progress of mediation in administrative matters? Actually, the analysis of diverse situations in member states revealed several obstacles, including legal, financial, structural, and cultural barriers. Concerning legal barriers, it has been noticed that in some Council of Europe member states, the legal framework for administrative mediation is too broad and lacks specificity due to the unique nature of administrative disputes. Additionally, the absence of a connection between the mediation process and the court trials also hinders the use of administrative mediation. This is the case in countries such as Bulgaria, Croatia, and Switzerland. Also, financial and structural barriers are slowing the growth of mediation in administrative matters. Although mediation is often seen as a cheaper option than going to court, this is not always true, especially when a professional mediator is involved. It has been observed that in many countries, there is no legal aid available for mediation, so the parties have to cover the mediator's fees themselves. Moreover, the lack of clear rules of mediation in administrative bodies and the absence of official lists of mediators in some states create further challenges impeding the use of administrative mediation. The final obstacle, as identified by almost all our national contacts, is the lack of a mediation culture among the relevant actors, administrations, lawyers, and court personnel. This can be attributed to a lack of understanding of the process, inadequate information about available procedures, and general mistrust of mediation. Some citizens believe that the judicial system is the only way to resolve administrative disputes, while a portion of lawyers untrained in mediation, of course, may resist to or discourage the use of mediation. All these factors contribute to the lack of a mediation culture in member states of the Council of Europe. For all these reasons, the CEPEJ has created a comprehensive guide. You can easily find it on the CEPEJ website. This guide provides a clear definitions of administrative mediation and offers 13 measures that member states can implement in whole or in part, depending on their specific needs. It also includes an annex with best practices from leading member states, which can inspire others to adopt these recommendations. Having presented the results of the CEPEJ study on administrative mediation practice in Europe, let's now focus specifically on the French experience. Actually, with the law of 18th of November 2016, France reintroduced mediation in administrative matters. Although mediation in administrative matters was allowed before this law, it was rarely implemented. So how have things changed since this reform of 2016? For example, what is the scope of administrative mediation today? Since 2016, mediation is allowed in all cases with no explicit exceptions. What are the different forms of administrative mediations that can be implemented in France today? Actually, mediation can be initiated within the judicial framework on the initiative of the judge or the parties, or outside the judicial framework without going to court, which can be a conventional mediation or an institutional mediation. Who can serve as a mediator in administrative disputes? A mediator in an administrative dispute may be a physical person or a legal entity like mediation centers. He or she may also be a professional mediator or an institutional mediator, whether he or she is part of the administration involved in the dispute or another public body. It can be a national mediator, such as the Human Rights Ombudsman, or a territorial mediator, such as the mediator of the City of Paris, or a sector-specific mediator, such as the company's mediator or post office mediator. The mediator can also be a judge who is a member of the court. And in this case, he or she will not take part in the deliberations if the case is returned to the court after an unsuccessful mediation. What about the practice of administrative mediation today in France? Well, I have some statistics. In 2017, the Conseil d'État, the Supreme Administrative Court and manager of the Administrative Jurisdictional Order, set an annual target of 1% of mediations initiated in a year. It means that administrative courts are required to refer 1% of cases registered in a year to mediation. This target has been reached in 2021 by the courts of first instance. 2014 mediation initiated out of 241,384 cases registered in all courts. Regarding the outcomes of these mediations, 54% of them resulted in an agreement. Now, what are the main areas where mediation is used in France? According to 2023 statistics, mediations were mainly initiated in 4 areas. Cases involving civil servant and public employees, 357 mediations, urban planning and development, 337 mediations, procurement and contracts, 268 mediations, cases concerning social aid, 133 mediations. Is there an obligation to attempt mediation in France? The answer is yes. Although consent is crucial for all forms of mediation in France, there is also a mandatory prior mediation known as Médiation préalable obligatoire, MPO. It means that the parties to a dispute are under the obligation to attempt mediation before going to the competent court. Otherwise, their appeal to the court will be declared inadmissible. It is important to note that this mandatory mediation is not a general measure. It only applies to resolving specific social disputes and cases where public officials and civil servants appeal certain individual decisions. The mediator in this specific type of mediation is necessarily a public institution, and the process is free of charge. Now, as a final point, are there any effective practices in France worth sharing? Of course, I picked just three practices that, in my opinion, have a great impact on the development of the administrative mediation in France. The first one is the appointment of a mediation coordinator in all administrative courts. It can be a magistrate, it can be a public agent. Another good practice is keeping mediation statistics at both national and local level that allowed the progress of mediation to be measured. The third best practice that I want to highlight here is the ethical charter, or this code of ethics issued by the Conseil d'État for mediators in administrative disputes. This charter sets out the principles of mediation, ensuring the quality of both the person conducting the mediation and the process itself. Principles such as confidentiality, consent of the parties, impartiality, and neutrality of the mediator. Defining these principles is crucial for enhancing trust in mediation as a new method for resolving administrative disputes. That's it. This was a very quick overview of the practice of administrative mediation in the Council of Europe member states and in France. Thank you very much for your attention. If you have any questions, please do not hesitate.
Пане Каріме, дуже вам дякую. Да, на жаль, сьогодні хочеться послухати всіх наших
Karim, indeed, thank you very much. We would like to hear all presenters, and we have quite a few lined up for later. So thank you for sharing the French practice. I'm sure we will be discussing many more things in the future, and if we need to learn something more about French experience, we will certainly get in touch with you.
Суддя Верховного суду Франції, пані Фредеріка Густін, якраз теж є
Frederica Agustin, I know, is a coordinator in Supreme Court of France on mediation, and I was also invited by Supreme Court of Ukraine to become an advisor on mediation issues here in Ukraine, and hopefully we will be able to promote this in the future. Next speaker is our colleague from Lithuania. She gave me shelter at the breakout of the war. Senior international expert, Virgilijus Volchans. I very much appreciate your support to Ukraine, our reforms, and we're very glad to have you today here. The floor is yours.
Зараз чуєте мене?
Так,
Just a
вас
second.
чутно.
Can you hear me?
Ви бачите мою презентацію?
Can you
також,
see
так?
my
ми бачимо,
presentation?
да, але вімкніть, будь ласка,
Yes, we can.
слайд-шоу, щоб було на повний екран.
Слайд-шоу.
Зверху слайд-шоу, animations. Ага,
Мгм.
правіше, правіше, правіше.
A little to the right.
Наступне слайд-шоу.
Окей, і зараз ми...
Play from
From
start,
start.
yes. Ага.
Окей, зараз, все гарно. Дуже дякую, пані Аліно.
Thank you very much, Alina,
За можливість
for
поговорити сьогодні
this opportunity to discuss with you and your colleagues. But first, I'd like to pass my regards to all
30 років медіації
mediation community in Ukraine. Over the past 30 years, you've accomplished a lot. But until humans are around on this planet, we will always need mediation. It will always be in demand, and it means we need to move forward.
На мою думку, є дуже гарний, оскільки
Today, I think the time is right for adopting mediation because we're moving forward to join the EU. And I will, by the way, cover some of these aspects in my presentation. Now, with your permission, I will switch into English because my presentation is actually in English.
In this slide, you see the very structure of my presentation, and the base of it is EU integration dimension. It is very much linked with the current position I occupy in Ukraine in Prawo Justice, EU-funded project, and together with other colleagues of the team who are helping, who are supporting the key beneficiaries of Ukraine in the EU, in the path of the EU accession. And you see here in this slide, briefly, I will talk about the accession and mediation, then a Lithuanian experience on judicial mediation a little bit, and mediation and administrative justice in general, and why not in Ukraine, as it was mentioned in the title of my slide. So EU accession and mediation, it was already touched by the other speakers today, and this is good news, that mediation is in the agenda of the European Union. Thanks to Council of Europe and CEPEJ works done, it was also presented during the morning session, and Karim made some references to that. And also at the EU level, there is a legal framework at the EU level as well. And this is why mediation is involved, the topic of the mediation is involved in bilateral negotiations. The first round first meeting for chapter 23, it's already foreseen for 17-19 of September. And it was also mentioned today, it will find its place in the roadmap, Дорожна карта, Ukraine, and this is good. Maybe just a little bit about EU integration agenda. I think we have a very nice opportunity, a window of opportunity, I would say, for mediation in general and for judicial mediation in particular, because this is my topic today, because this is not just European trend, this is not something Brussels or Strasbourg would like to impose to others. There is a quite good rationale before that. I started my judicial career in 1990, immediately after Lithuania regained its independence. And I have worked in Ukraine for many years, and I know the context of the country. And I must say that there are a lot of things in the society, in judicial society, in general society, between Ukraine and Lithuania because of the common past. I am not talking about common past hundreds and hundreds years ago, but the more recent common past during the period when a lot of things were imposed from the top. And I see mediation in general and as an alternative dispute resolutions part of ADR, that it should not be imposed from somewhere from the top. It should come, it should be bottom-up approach. But I absolutely agree, some kind of legislative guidance is necessary. And talking about coming back to the Lithuanian experience, I must say that this guidance, legal basis guidance, was quite stimulative for judicial mediation in my country. For instance, in civil cases, we have already quite advanced situation. In administrative cases, if you asked me to talk 2 years ago, I would say just the beginning. But now, I must say, we have some progress achieved, and I will touch upon it a little bit later. Judicial mediation started in civil cases in 2005. Mediators, both judges and non-judges, were admitted. We will see that's a bit different in administrative cases. And from 12 to 18, they increased 40 times. It's quite an impressive figure. And some judges, mediators, they became indeed the victims of their success. How it happened? Because they mediated quite professionally civil cases, including big corporate disputes. And then when the parties addressed the court, they immediately asked the mediation and expressed the will, the wish that the mediator X, the concrete mediator, would be involved. And I have talked with one of them, and he explained to me, wow, it's very now difficult to accept this, because I have a schedule of my cases to be mediated for 3-4 months ahead. So, and this is why I am suggesting other colleagues to be involved more. So small at the beginning, small cases like small civil disputes, and then it expanded to quite serious commercial cases. And here I could say that civil mediation or judicial mediation in civil cases is quite a success story in Lithuania. What's about administrative cases? We all know, because I've been working as administrative judge in my country from 2002 till 2013, and then more than 7 years I was a judge in Luxembourg, judge of the General Court of the European Union, which is supposed to be the EU administrative court. So we handled more or less similar disputes, but of a little bit different nature. So altogether, I have about 20 years of administrative judge experience. And I must say, indeed, because of these particularities, not all administrative cases can be mediated. We can say, okay, let us try all of them, but by the nature of some of them, it's very, very difficult to do it. We tried several cases. It was not mediation. We can say it was more conciliation or looking for amicable agreement in the general court, and some of them were successful, but I would say that the soil for such type of practice in the EU general court is not prepared yet. At the national level, in my country at least, we started to talk about possible mediation in administrative cases already maybe not 20, 15 years ago, but it was just talks. And at the beginning, it was a pure rejection because all judges, they didn't understand how it could be mediated. It was an approach, a mentality, a mindset some 15 years ago. From 2019, some kind of another new shift started and talks became more intensive. But I would say 2 years ago, 2022, was a breakdown in administrative dispute mediation in Lithuania because it started in reality. And we can say that from, let's say, 15 years ago till now, from pure skepticism, we are already at the stage that, well, it's indeed something, or even more, something plus. So this is, but this depends on judges. As it was rightly pointed out by Karim, the situation, the legal framework, legal basis is completely different in all European countries. For instance, in civil cases, anybody can be a mediator. In administrative cases, in Lithuania, only judges can mediate. Not it restricted to administrative judges. It's possible to be any judge. I don't know. As to me, it's a bit different. If I'm dealing with other type of cases, I don't know particularities of administrative disputes. Maybe it doesn't make sense to have. There is no difference for me either it's a civil or criminal judge or mediator in general. Maybe sometimes it might be even better. But this is the legal regulation. And I have talked recently with probably one of the most active judges mediators in administrative cases in Lithuania. He is from the Supreme Administrative Court, and he receives a lot of requests from the parties already from the very, very beginning of the dispute, which was taken before a judge in the first already instance, so it's possible. There is some practice. And for instance, right now in his portfolio, there are 25 cases to be mediated. And he already completed 9 cases, I think this year, or maybe part of them from last year. And with 7 positive outcomes. That means 7 cases out of 9 were successfully mediated. For 2 cases, it didn't work. The parties didn't come to the proper solution. And again, coming back probably to the more general debate or talks about mediation and administrative justice, I see it as a not only as a something like would help to disburden administrative justice system, administrative courts and judges. At the beginning, it will not be a case. Maybe after the big progress, it might come. But as we saw from French experience, it's a task from Conseil d'État, 1% per year. It's not a big figure at the very beginning. But I see more the very big advantage to promote this tool, mediation, in particular with, in administrative cases, because it helps to bring, I call it social peace between private parties and public authorities. And in any state, in any democratic state, it's very important that there will be no angry between private parties and the state machinery, the state administration. Of course, we're not naive. We will not achieve it for 100%, but using mediation and showing the positive results, we could reach the very, very good results. We saw what kind of cases and administrative justice in France could be mediated, and in Lithuania, they started with small tax cases, compensation of damages, public service disputes, environment protection is quite interesting experience. And, you know, I see probably several reasons why mediation could be successful in administrative disputes, in particular when first, the public administration has made some mistakes. It shouldn't be some big mistakes, but some minor mistakes, and the position of the public administration is quite vulnerable. It's one reason why the public administration could agree to go to mediation. Another reason, I think, another possible situation, then the public administration and the private party, they absolutely understand that if they follow the formal legal basis of legal framework or background, it would come to the dead end, and that means it will be you even could come to certain situation ad absurdum. Let me bring one case from the practice. There was the farmer he had some kind of bed of fallow deers, and everything was legal with all permits needed, and so on and so forth. And this farm was in the some kind of not natural park, but in the area, in the protected area with a special regime. And he decided to sell his farms together with the animals, and he did it. And the new owner started his activities in the same farm. He was quite experienced with the animals, but since this farm was in the protected area, he had to obtain some additional permits. And if you went through the ownership procedure, it could take years and years. And you can imagine that from the formal legal point of view, from the very beginning, his activity would appear as illegal, because without permits, he could not keep this bed, hundreds of animals. So what to do? And I must say, this case was successfully mediated, and thanks also to the goodwill of the public administration. It also understood that if in another case it would be extremely difficult, the farmer would oblige to kill all more than 200, I believe, those fallow deers, and then they found a solution, and thanks to a judge, a mediator, who also found the legal dressing, the legal clothes, because when you are facing such a irregular, not traditional situation, you need to find something, you know, also not traditional. And it was accepted, and it was extremely good for both parties, for the private person and for the public administration. And we could say, in this case, the wolf was full, and the sheep also was kept healthy. So now coming back to Ukrainian environment, we have started under Praво Justice certain pilot initiatives in Chernivtsi, in Lviv, and we'll continue in Dnipro. We had already some talks about that. To start mediation in administrative cases. Well, we can call it mediation room or kimnata, medicina kimnata, something like that. And I had talks with administrative justice from many regions. And I witnessed the very good, open, and very good willingness from administrative judges to be involved in it. This is already very good, because when I remember 20 years ago in my country, when I still was the president of the Supreme Administrative Court, judges were very skeptical. No, it's impossible. No. And now I see in Ukraine judges are in favor. This is okay. Good. EU acquis is, let's say, quite positive on this issue, and the timing is very good. We are in the process, in the path of the EU accession, in the process to becoming the EU member state. Procedural environment, to my view, is okay. We have the new law on administrative procedure, Закон про адмінпроцедуру. This is good. Probably we would need to make some legislative amendments or adjustments or polishing in order to have a more comprehensive legal framework. But for the beginning, for the start, I see no obstacles to. Even though in some countries it's called mediation, in some countries conciliation, in some countries peaceful agreement, or in Ukrainian it would be like примирение сторін. And in this case, for me, is the most important that the decision is not put from the top, from the judicial branch, from the state judicial branch to the parties, but the parties are actively involved in the process. And here I see, coming back to what I started with, I see quite a good potential as far as judicial authorities are concerned and administrative justice. Yes, we understand that it will not be easy. It will take some time. We would need to find some judges enthusiasts, and there are already some judges, some administrative judges. One of them, Andrei Rishenko, will talk in our panel, who already obtained a certificate on judicial mediation. And this is, I also received quite some demands from administrative judges, how and where it could be done and so on. This is very good that judges are interested in it. Public administration, this is a question mark for me. Still, this is why we are organizing roundtables between judges in some regions and local public administration in order to discuss openly what are the benefits of it, and in order to provide the clear message to them that it would be win-win situation for both. This is not something personally important for a judge or a civil servant, but in the broader sense, it's very good for the society and very good for the state. So, and I come to the title.
Пане Вергіліус.
Why not to
Mr.
start? Yeah, I
Vergilius.
think it's time, and pilots appreciate it. And sorry, I lost the timing, and this is why I coming to the very last of my slides. Cases should be properly pre-selected. Carefully try mediation tools. Convince public sector why it's better. Start with small steps. Keep going, and progress will come. Thank you. Sorry for being maybe too broad.
Пане Вергіліусу, дуже дякую.
Mr. Vergilius, thank you very much. Unfortunately, not you, but ourselves are limited in time. It is extremely pleasant for me to hear what you've just said when you were talking about best practices, experience, and prospects for the future. I'm so happy that Prava Justice continues supporting mediation, because I was part of this team. I was one of the national experts, and it's so pleasant for me that you push this support forward. And I absolutely agree with you that this is one of the windows of opportunities right now at this very important European integration stage. Mediation has to be perceived not something additional, not as something somewhere outside. It's part of the human-centered approach, as part of the justice process. This is important for courts because they can discharge the caseload a little bit, and they can also have options to choose from. In some of the specific cases, I think mediation is going to play a very important role, and it's going to be a role model for others. People going through mediation, they are much more conscious from the legislative and legal standpoints, and they are much bigger supporters of the judiciary system in general, isn't it? So, it is my pleasure to give the floor to Linda Reykjavik, and she will tell us a bit about the experience of the Netherlands. I had an honor to study in the Netherlands, and had an honor to meet Linda in the ICC events in Paris. Please, over to you, Linda.
Okay, good afternoon, and thanks to Alina Svetlana and her team for organizing this event. My name is Linda Reykjavik. I'm a CEO of the Center for Conflict Resolution, a mediator for 30 years, mainly in administrative law cases, and international consultant in a former career in about 80 countries. So I like intercultural administrative law cases. You make me very happy. So I will talk first about some of the cases in the Netherlands, and then I will on administrative law, and then I will explain something about the development of mediation in the Netherlands. Maybe Alina, you can start the presentation, because I understood one of you will manage the presentation. Yeah, okay. Thank you very much. So, my title of the presentation is Let a Thousand Flowers Bloom, because I believe that mediation really is on the grow. It's getting a huge flight, at least in the Netherlands, and I also see from other European countries. So if we can go to the next slide, please. Yep. So I will talk about mediation in the Netherlands, the development, mediation in administrative law cases, and also looking to the future, what can we expect? So let me go to this next one, and then you see this mother. Once Upon a Time, it's called. And this picture is symbolic for what happened in 2012 in the Netherlands. In 2012, the tax office, they withdrew social aid for families who had their children going to a creche, to a kindergarten. And because they thought a lot of people were being a fraud, the tax office, they required these families to pay back at least 40,000 euros within a certain time frame. And now for the past 2 years, so more than 10 years later, it became clear this was a big, big scandal. So this has been in all the newspapers and all the social media, this tax office scandal in the Netherlands, and it's about 55,000 cases. And a lot of these families, they had gone completely in despair at this time in 2012, 2013, because who has 50,000 euro or 40,000 euro on the shelf? Nobody has, especially not these mothers who most of the time were single parent families. So some of them really went into depression, some others lost their children, others, whatever the case, it was terrible. Now in politics, this scandal has been raised, and now the government has decided that in these cases, they will use mediation. And you can imagine that this has really given a huge impulse to mediation in administrative law cases, because the tax office, the ministry, really embraces mediation to, well, as a way of resolving these terrible issues. Now, if you look to mediation in administrative law cases, it has a specific dynamic. And let me go to the next slide. Because mediating with the government, it's a specialism. Don't think that if you're just a family mediator or labor dispute or whatever, you just can do it like this. Because in mediating with the government, it has a specific dynamic. Most of the time, a mediation with the government, of course, administrative law is the cadre in which the mediation takes place, but it also has a vulnerability of both parties, and it has hot-cold dynamics. Let me explain this. Let me start with hot-cold dynamics. Imagine you have a mediation between the government and a company. It's about their the company wanted to have how you call this their permission to build or to do their business, and it was rejected by the government, and okay, it went to court, and the court referred to mediation. Then on the one hand, you have this very, very, very angry company owner, because his whole company has fallen apart. I remember a case that the claim was at least 50,000 euro. Actually, it was a little bit more. And in this mediation, the government said, well, I mean, this is just the law. So you see, on the one hand, this government, who is, we call it the cold, approach. Whereas on the other hand, you have this company owner who is very, very angry. So this is the hot dynamic. And in such a mediations in administrative law, you have the cold dynamic heating up, and the hot dynamic, you have to cool it down. And then they can talk to each other. And in order to do this, you really need specific skills and tools. Of course, also, just imagine the picture with the mother, with terrible stories. On the one hand, you have the mother. On the other hand, you have the tax office representative. And with these stories of these mothers, these terrible stories, what happened to them and their families, it's difficult, of course, to stay neutral. But you all know that the neutrality of the mediator is the key of our profession. So how do you keep neutral if you see this crying mother all the time, and on this side, a tax officer who is showing this cold dynamic? Well, luckily now in these tax office scandals, of course, the tax officers also have seen these terrible stories, and it has a different atmosphere. But in general, if you look to administrative law cases, you will see this hot-cold dynamics. Let me go to omnipartiality. Most of the time in administrative law cases, you have more than two parties. So with the mother and the tax office, okay, it's just two parties. Because if you look to environmental disputes, I think Karim and Vilnius already mentioned some. I remember I had a case with the wind turbine company, a group of at least 20 citizens who were against the wind turbine park. I have one government, the provincial government. I have the local government, maybe even a national government. So you have at least 4 or 5 parties. That's different. That's different from just a 2-party mediation, having just 2 people at your table. So you have to really manage all these parties, because you can imagine also not only multi-party, but also hot-cold conflict. You have these angry citizens on the one hand, and on the other hand, the company, but mainly the government, who says, these are the rules, this is a legal framework, sorry people. But still, they decided to go into mediation. So as a mediator, you have to do your work and, of course, accept party autonomy, but also manage all these emotions, cold emotions from this side, hot emotions from this side, and staying neutral or omnipartial. That is important, aspect of mediation with the government. If I look to the different type of cases, you could have the following when it comes to mediation with the government. Like the one, a 2-party mediation on social aid. It could be an environmental cases where you have a company with the government or citizens with the government. Or you could have between governments, are also possibilities of having a mediation. Or you could have a mediation with a government and an NGO on a nature park, for instance, in the Netherlands. So there are a lot of possibilities where mediation in administrative law can be used. And that's why we see that mediation in the Netherlands really has come in administrative law, is rising, is becoming more popular. Because in the Netherlands, like in many other European countries, trust in the government is an issue. People feel that the government is not there for them. They feel this is a government at a distance, and they lose trust. Now, what you see in the Netherlands is that mediation is much more used also to close that gap between the government and its people. And that trust is built, rebuilt. And that's an important reason for the government to use mediation or to use mediation skills. And I come to that later on. But the key is, they call it responsive government, a government which is responding to the needs of the society. And like the 2 former speakers already said, mediation in administrative law really means something for society as a whole. So, some more examples is how you see that mediation is on the rise in administrative law cases is, by instance, that large ministries, like, for instance, the one I was talking about, the tax offices, but also the Ministry of Environmental Affairs or Internal Affairs, they use mediation much more and at mediation skills. Because it starts small, like Vilnius was saying. If an employee of a governmental body already can use mediation skills, not being a mediator, but just maybe 3-4 skills out of the 21, 25 we train, then he realizes, I can resolve this. Or he realizes that this conflict is really a conflict we need a professional for. We need a mediator for. And because we train them in referral to mediation, they know better how to motivate the other side in going to the mediator. So they know a little bit about the skills. They know how to do a referral. And that really gives an impulse to mediation in administrative law cases. They motivate other people to go to the mediation table. Let's jump into the next subject, which is about, one more slide, please. I think I already told you about this. Mediation in administrative law cases, you will see on renewable energy. And this one is also a growing field. climate change, I predict this will be the main field in the future. Spatial planning is already there. Let's go to the next slide. And let's jump, because of the time, I think, to how was the development of mediation in the Netherlands? Well, like I said, you see growth in all directions. The tax scandal I already mentioned. It was the first project to start 2 years ago, in which the government makes massive use of mediation. 97% of these cases were resolved. Huge success. The gas extraction or the gas mining in Groningen is going to follow this autumn. Another 100,000 households who had a lot of damage on their houses because of the gas mining in the northern part of the Netherlands. The government has decided that these cases also will be mediated. So it is mainly on personal injury, on damage, etc., etc. You also see other projects, municipalities, provinces, but also banks. So mediation is growing in all the directions, not only in administrative law, but also in other fields. Let's go to the next slide then. Okay, if here you see, like in most countries, mediation started with family mediation. Actually, 31 years ago, the only cases which were there was family mediation. My first case was on family mediation. There were no other cases. Gradually, labor disputes became more popular. And now you will see that 27% of all cases are labor disputes, whereas family mediation is still 66%. Then, and I was very proud I'm very proud to say so, our Center for Conflict Resolution were the first ones to start mediation in criminal law. We trained all the courts in referral to mediation in criminal law cases. Huge percentage of these cases are successful. 95% of the cases have a final agreement. And unlike in other countries, business mediation is not yet that popular in the Netherlands, but administrative law is. So there is a lot of growth in this field, like I was just telling. And I put here the innovation adaptation curve, and we're really on the left-hand side. We're on the rise of mediation. And I will come to an explanation why it is on the rise. Let's go to the next slide. Because the main thing is that I put it like this nice picture from Vincent van Gogh, the sewing man. You have to sew, building the profession, building society, make society aware. So in the Netherlands, we have no law on mediation, strangely enough. But we do have the Mediators Federation, which is the registration body of all professional mediators. If you want to be a mediator doing cases for courts, or like the tax office or for municipalities, you have to be an MFN accredited mediator. And they have a well-known and outlined framework on what a mediator should do and how we should behave. In 1998, there was also the NMV was founded, which are in the interest of the mediators. So the registration body is in the interest of the profession, that clients know exactly this is a professional and accredited mediator, whereas the NMV is in the interest of the mediators. And they also do a lot of PR for mediation in the wider society. Another subject was referral to mediation, like I said, with the courts, that really contributed to the rise of mediation. Publications on whatever the subject, and I'm happy to say that a lot of our trainers and mediators, they have written the standard publications on mediation, like Professor Allewijn. He has the standard publication on mediation in administrative law. What also helped a lot is scientific research on mediation. We established the first professor in mediation, and it really have given a boost to mediation in the Netherlands, because now it's an official academic study. So that really helped. Let's go to the next slide, please. So that was sewing. And then I realized that mediators are not so much familiar with academic research. So if it's not there, then I thought, well, let's start something. So in the past few years, together with the MFN, the Center for Conflict Resolution, we organized a kind of pitch or TED Talk on mediation to share academic research to the professional mediator. And then the next thing what we did in stimulating research was having a network of universities and having scientifics, academics, professors, researchers in mediation to share amongst each other their research. And this really gave a boost to mediation as a profession, because now you have statistics, now you have evidence-based research. And it could be in any field, economic field, neurobiology field, why are emotions working, or emotion management, why is it working? Of course, the legal field, anthropological field. So all these researchers, they share their knowledge with each other. And hopefully next year, we will do an international version. So I would like to invite scientifics and academics who are working in this research fields to contact me. The main thing I want to say is after 30 years, it took at least 30 years, now you can see that mediation is on the rise. But small steps, like the former speaker said, small steps which contribute to mediation. And sometimes you feel, oh, it's never going to happen. And then suddenly, like this. Maybe some of the last slides. Well, you know the proverb, he who sows will reap, because that is important, like I said. In the end, you will reap, you will have your harvest in mediation. And whatever the mediator, as long as it's a professional mediator. In the Netherlands, it's not necessary to be a judge. It's not necessary to be a legal professional. Anybody can be a mediator as long as he is a professional and accredited by the MFN. Then, and I think that's very important, that the public gets confidence, trust in a mediation profession. And that's what you see right now. So let 1,000 flowers bloom, definitely in Europe, definitely in Ukraine. I think it will really help the public, society, and peace. Thank you very much.
Шановна пані Ліндо, дуже вам дякую. Насправді Нідерланди це справді для мене
Linda,
завжди
thank you very much for your presentation. The Netherlands has always been a very, very good example for us, because even though you don't have the legislation, you kept sowing. And indeed, now you're reaping a very good harvest. It's an excellent example, and this means the society understands how useful this is, and especially in administrative cases, even when one party is a state or the government, we must always remember that the other party, the second party, is the citizen, you know, of this country. So thank you very much again for your wonderful presentation, for very nice comparisons, and I'm sure our participants enjoyed listening to you, because you were talking about theoretical things in many cases, but you presented them so well that it was very easy to understand, and everything was very clear. So now we still have a few more presentations, and I'd like to give the floor to Gerard Carbal, Director of European Institute of Mediation and Public Ethics and former advisor to the Ombudsman of Spain. Thank you for joining our forum. The floor is yours, Mr. Carbal.
Thank you very much. Good afternoon. Thank you, Alina, and to the organization for inviting me to participate. I don't know, can you hear me?
Так, ми чуємо вас чудово.
Yes, we can hear you loud and clear.
Okay. It is a pleasure to share with my dear colleagues our experiences regarding mediation in administrative law. I believe it's very important to draw various conclusions that allow all European countries to consider these issues from an integrative perspective within a framework of democratic values that inspire the functioning of our European institutions for the defense of human rights. In Spain, we have recognized that administrative mediation is not just a procedural or alternative conflict resolution mechanism. It is also a new form of citizen participation in public affairs that affect them. It is also a mechanism that ensures and preserves the principle of good administration. And last but not least, I believe that mediation is a new model of administrative justice that naturally integrates the principles of defense and effective judicial protection. Therefore, the synergies that lead to this paradigm shift are those that bring about a change in the administrative behavior of an administration that was previously self-centered at its imposing and reactive self-protection procedures towards a more consensual, informed, open, and transparent administration that prioritizes and focuses on the citizens and their interests and need. In Spain, the interest in mediation arose as a result of our administrative legislation, which establishes the possibility to ending administrative procedures by means of pacts, agreements with public administration, in order to prevent citizens from taking legal actions against administrative acts that could harm the rights of individuals. However, it was not until the Council of Europe's Recommendation 9/2001 on alternative dispute resolution between the administration and private individuals when there was a change in the understanding of relation with citizens, to the extent that Spain already has an ADRA, Alternative Dispute Resolution Administrative System, in various scenarios where the Council of Europe has placed administrative mediation, as can be seen in the important guide published in December 2022, promoting mediation to resolve administrative disputes in Council of Europe. Indeed, the Council of Europe, following surveys of experts in different countries, has established 3 models of administrative mediation: institutional mediation, conventional mediation, and jurisdictional mediation. These are 3 types of mediation which are developed respectively: 1, by the Ombudsman, institutional mediation, to control cases of maladministration; 2, mediation to prevent and resolve conflicts in administrative procedures, conventional mediation; and 3, mediation which takes place when judicial proceedings have been initiated in a court and the judge refers the case to mediation with the aim of getting the parties to agree a solution to the dispute. This is jurisdictional mediation. This experience in Spain have shown the importance of this system in resolving administrative dispute here in our country. Although my country does not have a specific law of administrative mediation like occurs in France. The fact is that we have developed good mediation practices thanks to determined push of the European Union and the recommendation and guidelines of the Council of Europe. The current situation in Spain shows that the mediation of the Ombudsman is considered essential, and that is very important to this office to have a special ADRA section to which complaints are referred before a solution is adopted. As with traditional mediation, ADRA systems are also used for complaints to municipalities and some government agencies on a variety of issues ranging from nuisance, noise, waste, damage, urban planning, and the environment to public safety issues, and fines or penalties imposed on individuals. Finally, it is important to highlight jurisdictional mediation. Since the General Council of the Judiciary in Spain has led the implementation of this ADRA system, providing all legal actors with a guide so that all administrative courts have strategies and resources to refer dispute to administrative mediation before the judicial process ends with the issuance and a court order. In any case, in each of the three types of mediation, the subjects that can be mediated are unlimited, except for cases that could violate the legal order, public interest, or those that are expressly prohibited. Experience has shown that the cases submitted to mediation are very diverse, and that the cases of mediation that result in an agreement at the end of the mediation process are 7%. The variety of areas and competences that can be resolved through administrative mediation system highlight its importance as a factor that generates trust between individuals, intervening in a safe environment for dialogue and communication, and helping to find peaceful solutions to conflicts through active participation as an expression of the development of citizenship through a new social dimension that allows to maintain an European model based on the welfare state. In this context, it is important to emphasize that if mediation is making progress in the various countries of our continent, is because it defends these institutions on the basis of a framework of values anchored in respect for the Charter of Fundamental Rights of the European Union, and in particular, the right to good administration enshrined in Article 41. The values, principles, or rights contained in mediation are based on a common identity shared by the European Union and the Council of Europe, and are therefore centered on respect for human dignity, freedom, democracy, equality, the rule of law, and human rights in a society characterized by pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men. I want to say something that is very important to me, and I do it with an open mind by way of reflection. I believe that the time has come to encourage the European Parliament within the framework of its powers to draw up an European directive on administrative mediation with the aim of creating an appropriate scenario to establish a new relationship between citizens and public administration, and at the same time definitively enshrining the right to good administration. This implies a greater participatory presence of citizens in the matters that concern them, and a broader and more comprehensive way of guaranteeing a quality democracy. We need a European directive that must reject the old dogmas that mediation does not fit into our system because of a cultural problem. The challenge is to overcome resistance to change and to bring power structures into line with efficiency and the idea of effective service to the citizen through good administration. It's necessary, I think, to break with the current authoritarian model of administration based only on administrative prerogatives, on the administrative silence, on de facto action, and finally on the acts of maladministration. An European directive that puts forward proposals aimed at finding a model in which public policies focus on the real needs of citizens beyond the bureaucratic mechanisms and structures of the administration. In short, a directive that adapts to the new technological challenges based on online dispute resolution, based on metaverse, on scenarios and artificial intelligence system, AI, within the framework of the 18 Sustainable Development Goals offered by the United Nations in Agenda 2030. Having examined the various aspects of administrative mediation as a factor of cohesion and a rule of values in 20th century Europe, we can conclude that we are in a position to contribute to the cohesion of the European Union and to the return to the values contained in the Charter of Fundamental Rights and the principles and values upheld by the Council of Europe. Thank you so much, and congratulations for the participation from my colleagues. Thank you.
Джерардо, я неймовірно вам дякую, бо ви
Gerardo, thank you very much. You are right on time, and thank you for sharing your views and the perspective from Spain. I spoke to administrative judge from Madrid recently, and he confirmed that judges in administrative justice are interested in this, in mediation, and it's important to move forward. So thank you again. Now I would like to give the floor to our next speaker, Andriy Rishchenko, a judge from Dnipropetrovsk District Court, president of GEMME Ukraine. Since 2015, he's been supporting development of mediation very actively. Back then, many were quite skeptical about mediation. And by the way, we have a question in the chat, and perhaps you could touch upon this in your presentation and tell us a bit more about Ukraine experience. But also perhaps you could take this into account. If I could intervene just for a minute, I am so impressed by the presentation of our speakers. I have a proposal. After this session, we will have a long break between our evening session. I suggest we add a bit more time, because now in the chat we have very quick, very interesting questions. So let's have the next presentation first, and then we can respond to questions from the audience. Okay, thank you. The floor is yours. Thank you, colleagues. I like this event. I think it's a good tradition to hold these exchanges, these meetings, and thank you for inviting our foreign colleagues and international experts. who are sharing their perspective on this. Now, imagine a few years ago, a person with a grenade takes a hostage, like a ministry, for instance, having two decisions of administrative court
адміністративного суду на його користь.
in his favor.
Тобто ми бачимо конфлікт, який
So
був
we see
перегрітий.
a conflict that was overheated.
Що пішла на такі категоричні заходи і відчуває себе непочутою з боку держави.
And the person was, he felt that no one was listening to him. His voice was not heard by anyone. He felt left out. Well, the idea is to make people speak and let them speak out and speak their mind. So let me turn my presentation on. Can you see it? Yes, we can.
Перш за все, треба сказати, що медіація
Well, first
вже
of all,
довгий час
what I'd like
працює
to
в
say
Україні.
is that mediation has
В тому
been
числі
used in
ми можемо
Ukraine for
сказати,
quite a long time.
що ознаки
And
потенціалу медіації в адміністративних спорах ми
The
бачимо
potential for mediation
вже
in administrative cases
стільки років, скільки існує адміністративна юстиція.
seems to be
Щодо
indisputed and
можливості запровадження
very good.
адміністративної медіації,
As far
у
as
нас
introduction
вже
of
мої
administrative
колеги сьогодні
mediation is
назвали
concerned,
рекомендації
well, we heard
десь
quite a
також,
few references.
які
We heard
зазначені
recommendations
вони зазначали,
from
чому
the Council
важливо
of Europe.
проводити медіацію в
Those
адміністративних
explain
спорах,
why it
які
is important
способи
to use
вирішення спору,
mediation
а це
in
саме
administrative
питання
cases,
наближення
in
органів
administrative disputes,
державної влади до громадськості.
because
Ми бачимо,
these
по всій
bring
країні
government
світу зараз,
agencies
дуже високо стоїть проблемне питання щодо зниження довіри до держави,
cases.
до державної
This
до її представників, до суддів і
is
так далі.
detrimental
Тому що,
for the trust
як
of
би нам не
citizens for the
хотілося,
government, for the
але
state.
змінилися і
No
структура
matter
інформаційних технологій,
what we think
і,
about it, the structure of
порядок
IT is
отримання
changing,
людьми інформації. І
the
зараз
order of how
отримати якісь
people
позитивні
receive
відгуки щодо
information,
роботи державних органів дуже складно і налагодити такий діалог зі суспільством. І це дуже
and
важливо.
building this
Це
trust and
дуже
dialogue
важливо
with
в
society
країні,
is not
яка
easy.
зараз перебуває у стані
Yet it's very important,
дуже страшної
especially
війни,
for a
коли ми
country in the
бачимо,
middle of the
що
war,
суспільство перегріто, особи не можуть отримати допомогу у своїх питаннях. Ми
and
дуже
the
поважаємо
society is overheated.
Збройних
Many
Сил України, але
citizens
я вам скажу на
do not
власному
get
досвіді,
answers.
на жаль, дуже багато випадків
We
вже трапляється,
now
коли
see
такі особи
quite a few cases when Ukrainian servicemen,
подаючи якісь документи
when they
або
submit some documents,
маючи певний адміністративний спір із державою,
or when they have some
коли їх
administrative
права якимсь чином були не
dispute
захищені,
with
вони
the
вже
state,
телефонують до судів і
they
погрожують
phone
застосуванням зброї, застосуванням
judges
певних якихось активних
and
дій.
courts
Тому
and
я
threaten
дуже
the
радий,
use
що
of
зараз
weapons.
ми зустрілися спільнотою,
So
мабуть, найпотужнішою
it is
медіаторів
good
нашої
that
країни,
we
і ми
can
повинні усвідомлювати, що ваша в першу чергу робота це буде
use this,
працювати з людьми для зниження
and it
таких
is good
градусів
that we can work on
такого
this
градусу конфліктності.
and
Або
minimize
зробити можливим для того, щоб такі
this
конфлікти
the degree
вирішували
of
в більш цивілізований
of
спосіб.
conflicts.
Мої колеги також
My
зазначали,
colleagues also
я
point
дуже-
out,
я не буду повторювати те, що сьогодні звучало,
and
тим
I
більше,
don't
що
want to
сьогодні
repeat
були
what was
присутні
mentioned
і автори,
earlier,
цих
especially
гайдлайнів, і
because we had
рекомендацій.
representatives
Тому я
of
не буду
different
повторювати,
countries,
що було
and
вже
they referred
проговорено,
to
але
recommendations,
давайте
so I don't want to
поговоримо про те,
repeat
що у нас зараз
what they
існує в
said.
Україні.
So
Щодо
I'd
медіації
rather
в
focus
адміністративних спорах.
on
Кожного
current
разу, коли наша
situation
організація
in
проводить певні
Ukraine.
навчальні
Every time
заходи,
our
ми,
organization
свої учасники,
conducts
завжди проводимо опитування щодо
some
перекон,
trainings, we always poll participants about the obstacles in administrative cases. Then we ask them, what would induce you to use mediation more often? And often they are people, they're the legal representatives, lawyers, professional lawyers, and they may not necessarily represent the opinion of the whole society, but when we ask the legal experts, very often they ask and raise the issue of, even though mediation is growing, it is not very well known in the society. In other words, rank and file citizens know very little about it. They have heard very little about this. And in Ukraine, there are several registers of mediators, but people don't know how to find them. And what people also don't like is that there are several of those. They see a problem in this because if you favor one register, it creates inequality, and if a government agency prefers some other agency, they may be accused of corruption. A third obstacle is that people think that agreement reached through mediation will likely not be enforced. And there are around 15% of respondents who stated that. Now, if we look at another side of the coin, what could promote the use of mediation? Well, I believe successful cases, successful settlements would promote this more than anything else. And in administrative courts, we could get these good examples. What can we say about national experience? Well, we see our cases, and then the Supreme Court approved those cases, and approval from the Supreme Court are very few. In some regions, they are present, but I would say there are only around 30 of those in total to date. Alina mentioned that since 2015, we've been trying to popularize the mediation with assistance from Право Justice Project in particular. But we have quite a few cases when the case is closed, the lawsuit is withdrawn, one of the parties recognize the results of mediation, and this indirectly shows that mediation works, and this percentage is increasing. So to say that mediation is impossible in Ukraine is wrong. Regarding administrative cases,
самостійно робили висновки про те, що
we came to the conclusion
основних проблем це є неуповноважений представник.
that one of the problem is that unauthorized representative, lack of understanding of mediation, how it works, where you can find a mediator,
Дуже важливо, відсутність самостійності суб'єкта владних повноважень. Що мається на увазі?
lack of independence of the government agency. Because in our legislative practice,
багатьом державним органам
many government
встановлює
bodies
настільки вузьке, що у суб'єкта владних повноважень
establish such a narrow regulation that the government representative doesn't have the discretion to make a decision. And this leads often to cases
розвитку медіації в адміністративних спорах.
and this could, progress here could improve the situation. And currently, only local self-government, organs of local self-government have wide authority and mandate.
So they now the broadest discretion possible in so many issues. And most importantly is that they are at their level and able to make their own decisions without approvals from the top level bodies. Now, and now the last point that I wanted to mention, what creates another obstacle for amicable resolution and mediation or reconciliation, this is when the subject of the dispute is money or property, where there's increased attention from the oversight agencies like there used to be the Control and Revision Service. We no longer have it, but these disputes may often create grounds for holding government officials accountable. That is why when the dispute is about property or money, they try to block those cases and try to push forward all those bureaucratic procedures without even a single attempt to employ their discretion because they're just scared. And most importantly, what creates an obstacle for reconciliation and mediation, you cannot see it on the slide, but it's there. This is individual leadership from the top level officials in government agencies. So whenever we're talking about independence or autonomy from local self-government bodies, then when we're talking about executive power agencies, they have a clear-cut hierarchy. There is a region, there is national level, the ministry, and then the regional level and the local. At this stage, there is a lot of dependency on possibilities for engaging mediation, and a lot depends on personal leadership of those government officials who are ready to take responsibility and find for ways to engage this mechanism as one of the ADR solutions. Now, those potential disputes which we can see in administrative proceedings, you can see them just as an example. We had a lot of cases in administrative courts regarding challenging administrative debts, where the administrative debts were so obvious, and those cases were initiated by parties just to get an additional time, just to secure a postponed payment of their liabilities. It was due to the COVID-19 situation. Right now, this is because of the war, and the parties are trying to find the loopholes to secure additional time for their survival. At the same time, when the tax code contains the mechanism of postponing those debts, tax debts. But given the tax authorities' opinions, and given they're not always ready to be in touch and communicate on such disputes, we have a lot of cases like this that could be resolved through mediation. I think these are the main things that I wanted to highlight here in my presentation. And let me come back to the beginning of my presentation. I really encourage the entire mediation community to turn in, be engaged, and talk to our people, because they are absolutely in big stress from this situation. We can see that every day when they come to courts, they just need support, they just want help, so that those disputes and conflicts to be resolved in a more civilized and amicable manner. Thank you very much for your attention. Andrei, we want to thank you so much.
Зосередили увагу на тому, що
You have focused our attention on the fact that the level of emotional restraint in the country is so huge, and it is still growing. There is a lot of stress due to the war. It's a difficult war that we have to survive. And thank you for focusing our attention on opportunities for courts, because there are alternative dispute resolution mechanisms that are viable, absolutely. And the most important thing to hear is that the judiciary supports mediation and its development in the future, and this is so important. I know that Luisa wanted to say something, and then we're going to move to questions and answers. Please, Sophia, I can see your raised hand. I'm going to give you the floor a little bit later. Thank you, Alina, and thanks to all the speakers. That's very interesting, but I feel more affinity to what Andrei has been speaking about, because it's so true for our country. I'd like to underline exactly what Andrei has mentioned. We want to join this movement and maybe highlight some of the more important points. This is about the fact that we really have artificially created categories of cases which just create additional burden and caseload for administrative courts, because at the state level, there is a legislative loophole providing for a certain right. And everybody wants to exploit that one, you know, just to postpone something, to win a little bit of more time. And that creates a huge caseload, and everybody wants to take advantage of this. Now, again, to confirm what Andrei has said, we have indeed a great problem in the entire country with sharing information. And Roman mentioned today at the very beginning that as a result of the hearings, they supported an idea to create a coordination center or council, so that the right hand understands what the left hand does. You know, because there are so many great experts here in the room, over 300 people on the call with us. How many of you are aware that in Odessa, since 2019, I think, they already have mediation rooms in their administrative courts? That's the trial court, I mean. Last year, they opened a mediation room, and also in the Court of Appeal. This is the 5th Administrative Court. So there are opportunities out there, and how many people have heard about it? Not many. That's the problem that I mentioned. This is a problem in communicating this information. How many of you have heard that there is a one-stop register that was organized in the first days into the war as a response to government agencies' requests? There was a coordination meeting right after the war started, involving legislative, judicial, and executive powers. There is a register called Mediation Help. There is one more register in the pipeline. This is mediators.com.ua. This is an interagency platform that we established together to fix some of those problems when judges or government officials do not know where to refer those cases to. We need to make sure we know about all those opportunities. We need to communicate this together with our partners, together with all the stakeholders, and those enthusiasts, as we call them, that push mediation forward. I would like to demonstrate something. I'm sure at least 300 plus people will know about it now. Let me again show you the judicial portal. Now a representative of the High Council of Justice has already shared this information with us. It's not a website that we can see, but a nice picture of yourself with a nice girl. There you go. So this is court.gov.ua. If you can see it, yes, we can. Perfect. So this is the judiciary's portal. But now the question that we have, how to find a proper mediator? We've been facing this issue for so long. It was a conscious choice of the mediators community for us to have a single one-stop solution where to look for a mediator. We were taking stock of so many different experiences from across many countries and realizing all the challenges that we'd been facing, we tried to choose to have at least a one-stop place where one can go and find a mediator to minimize different risks and then influence positively access to the profession, to the occupation. So how to find a mediator? You can go here on the website. There is a reference to the law on mediation. So there are mediators registry, which are available online, which means there is no one-stop register for all the mediators. But for your convenience, you can actually go to this website, like mediation.help, and we invite all the mediators to go register over there. It's not the register that belongs to a specific organization or government body. This is a cross-government or whole of government register. It's not even the whole government. This is a holistic register where you can go and sign up. It's a free of charge register. And therefore you can please take benefit from it. Not everybody knows about it, but hopefully with today's forum, many more people will know about it now and use it for their own course. So we can move forward and develop mediation even more. I know there are so many questions in the chat and we would appreciate getting answers to those. Well, I think to some of the questions we already received answers because people were talking about the different categories of cases where mediation is possible. We want to thank Andrei for explaining that. There were other questions such as what kind of steps do we need to take to make mediation efficient in the country? I think we've been talking a lot about it already. There has to be active engagement of many stakeholders. This is what Virgilius and Andrei mentioned together. All the stakeholders have to be engaged. That's important. I mean, mediators, government agencies, judiciary, lawyers, notaries, everybody, and also enforcement officers, as well as citizens. I think only when we build this synergy and we take everybody on board, it is going to work successfully. Because we have a lot of expectations that somebody will do something for us, but I really loved what Linda mentioned, that we've been seeding something for 30 years, and then there is time to sow, you know. We have to keep going for the results, for the benefit of everybody. If we want to seek the result, we all, citizens of Ukraine, have to do something. We all benefit from it. And this is going to be a solution away from the court to find a resolution to whatever dispute. There was a question to Mr. Gerardo. Gerardo, how can you see the role of GEMME in supporting mediation, and what steps can be engaged to improve the situation? I think you can talk about the role of GEMME that it plays in Spain, but what about Ukraine, the Ukraine's context? Thank you.
Oh yes, GEMME is doing a very, very important work. For example, in order to explain the current state of administrative mediation in Spain, it's necessary to highlight two important and recent work carried out by a group of experts in public law. And GEMME, for example, on the one hand, have done the publication of a book entitled Mediation with Public Administration, and which is the result of the research carried out by a working group promoted by GEMME Spain. And this organization are doing a good and important job in the judge, in the courts in Spain. And I think that the research, the actual research, go to the courts in Spain of the community autonomous, practice the mediation intrajudicial contentious administrative, because on this moment there are not a situation of the quality, because only are mediation in the judges, in the courts, in some community autonomous, for example, Madrid, Barcelona, Andalusia, but not all the autonomous community are mediation. And GEMME is working for installation, total installation and use of the mediation, judicial mediation contentious in all the territory of Spain.
Дуже вам дякую, пане Джараде.
I want to thank you very much, Gerardo. Let me underline, indeed, I had an honor 2 years ago to observe what GEMME has been doing in Europe across so many different countries, how much active the judges are, because they show a lot of interest in promoting mediation and pushing it forward. This year, there was a GEMME General Assembly in Paris, where Ukraine acquired a special status at the National Ukrainian GEMME Section already exists in Ukraine for almost 2 years, and we received a partnership status. In spite of Ukraine is not yet an EU member state, but we're so much grateful nevertheless that European judges understand the importance to implement mediation properly today and cooperate with the Ukrainian judges and courts. And we need to take steps together for Ukraine's integration into the European Union in this angle, in this part of the journey. I think this strong synergy and cooperation with the judges, Ukrainian judges and European ones, through GEMME Ukraine, will contribute a lot to best possible outcomes. And of course, we're going to get involved in active promotion and development of mediation in Ukraine altogether. Okay, I'm so much grateful. There was a raised hand from someone, I think. So I'm going to ask to turn on the mic and ask the question out loud, please. I understand somebody wanted to voice the question. So please. Oh, we're not yet there. Oh, we can't. Somebody says in the chat, I cannot turn on my mic. Which is a pity, isn't it? I mean, one has to raise the hand first. Oh, Sophia Zladovska. Good afternoon once again. I want to thank all the speakers. I wanted to ask a question of this nature. What's the ideal model that you can see that could be borrowed and implemented as part of mediation in administrative cases? Is there a best case scenario? I mean, best role model to follow? Thank you. Dear speakers, maybe somebody wants to share your experience and your vision about what model can be considered the best, maybe ideal or at least better than the others.
Can I ask what
Please,
you
Linda.
meant with model? Because I can give many answers, but let me first clarify, what does the speaker or the questioner feel with what is model?
Пані Софія, прошу уточнити ваше питання.
Sophia, if you can specify what you mean by a model. Maybe there was something about the role model solution, as far as I understood.
Будь ласка, дайте. Ага. пані Софії право
If you can
говорити.
give the floor to Sophia,
Я
please.
хотіла б уточнити,
Yeah, I just wanted to make it more specific. Is there any good solution for mediation somewhere for administrative cases? Maybe there are principles
Я
or
хочу уточнити. Ви маєте
best
модель
practice.
взаємодії з судами,
You
або
mean the model
використання
of how
специфічних
courts can
технік? Що ви маєте
cooperate,
на
or you
увазі?
mean techniques?
використання специфічних
I
технік.
mean, yeah, techniques. The technique side is more important for me.
Okay, I think like I explained in my presentation, a mediator in administrative law should have an idea about the dynamics within the government and within the government versus a citizen or another organization, like an NGO or like an entrepreneur. Because, like I said, the hot cold dynamics, and I think they're more or less universal, what I have seen in different countries. And this is very specific for mediating with the government. So I feel that in specific trainings, mediators should know how to handle these dynamics. That's for one. And secondly, how to handle multi-party cases, because most of the time, administrative law cases, there are multi-party cases. Not all, but many. I hope this answers her question.
Дуже дякуємо, пані Ліндо. Я сподіваюся, що пані Софія отримала свою відповідь. Я бачу ще одну підняту руку, пан Самуель.
Thank you, Linda. I can see another raised hand from Mr. Samuel, please. Samuel?
Прошу.
Please,
Hello,
Samuel,
good
the floor is
afternoon.
yours.
Yes, please, can you hear me?
Так.
Oh, yes, we can.
Yeah, I'm Mbawen Samola Wimpini from Ghana. I joined the program very late, and I want to thank the host and the speakers for the good work that they are doing. This program is a very good program, and it is very educative. My challenge is the time zone. You already know the time zone. I'm from Ghana, and I find it difficult to predict the exact time to join the program. So I'll be very grateful if you can educate me on the time so that tomorrow and the subsequent days to come, I shall be on time. Thank you very much. And I will be very grateful to know the main motive of the program, because I was in a platform when this link was forwarded. And I'm also highly interested in programs like this. That explains why I registered yesterday, but I missed yesterday's program. That was it on my side. So please help me to follow the program throughout the end. Thank you very much.
Дуже дякуємо, пані Софія. Нам дуже
Thank you so
приємно,
much, Samuel. It's so nice that we are listened to from all around the world, and there's so much interest in so many different countries for the forum that we are running this time in Ukraine. For us, this is a really strong signal that mediation has no boundaries. And Ukraine is known, not only for itself, but for mediation as well. I think that the hosts will respond to this request. Yeah, this is a question to me, I think. Thank you, Samuel, for being with us today. Thank you for joining us. Despite all the challenges, you found this time and opportunity to be with us. And we will share the agenda in the chat. This is a link to our website with the forum agenda. It always indicates time and this international sign, like GMT plus something. But we're going to share it in the chat once again so that you have this reference to a very convenient format. Maybe it's going to be more useful for you. There's one more resource that helps you translate your the timing into your time zone, so you can read it more precisely. You can just enter this Ukrainian time from the agenda, and it's going to convert that into your time, the time in your country, in Ghana, in this situation. We have the public chat, which we started, and we post there all presentations. We share all the materials and information about all the partners. We also post there all the information about the hosts and co-hosts. We keep sharing even more information there. All the presentations are bilingual, both in Ukrainian and English, and some of those materials are translated as well. So please, you can easily select something that might be of use for you. Even if you missed the presentation, for instance, you can actually have access to it through our chat.
Далі, на що ще звертаю увагу? Оскільки в нас зараз, я
What's
казала,
also important to mention,
проблеми з електропостачанням, і навіть
because
не
we
всі
have
учасники
challenges with electricity supplies, and not all the participants from Ukraine can get connected, can join us today, because they have blackouts.
увімкнули, наприклад,
Sometimes
електропостачання, і ось вони теж
the electricity, they have electricity and they join us and then they just drop out because there is no more power supply. For this purpose, we are recording everything in both channels. So afterwards, we're going to share it on the same page that you can see where the forum agenda is. So you can see all the previous activities, and you can actually go and see the agenda, all the recordings, all the panel discussions. Like we did last year, so don't worry. In case you missed something, God forbid, all this information will be available at your disposal. So we will certainly share everything with the certificates, with everything. There'll be a one-stop page with all the recordings. We're going to try to be as agile as possible to also be mindful of the time difference. I have to confess, we have almost 2,000 registration, out of which 1,200 were from Ukraine and around 800 were from all around the world. We realized not everybody could join us. That's why we are doing the recording. So thank you very much. Hopefully this information was useful for you. We will share all those references from time to time in the chat, so please take advantage of it. We try to create as much comfort for you as possible so that nothing gets lost, because sometimes you want to revisit something, listen to something again. I will certainly be watching all those videos and listening to all the interventions again and again, because they were amazing, fabulous. Thank you. I want to thank our speakers today. For me, this was an incredible pleasure, an honor to be part of this entire community and talk about this very important topic as a mediation in administrative cases. That's indeed about the dialogue between the state and its citizens. I'm sure that we're going to have many more opportunities to invite our fabulous speakers and discuss this topic again and again. Hopefully, we will host you eventually in Ukraine. You will be able to come in person once peace is established after our victory. And already next year, under the auspices of this forum or many other activities, we will be able to successfully and safely invite you to Ukraine. Dear speakers, thank you for your time. We're grateful for your expertise. Thank you for finding your time to share your knowledge and expertise with the Ukrainian peers. This is so valuable for us. And I think we can be adjourning our meeting now. What we're going to do, we're going to take a break now. So the break is 2.5 hours, given the time difference. So it's going to be like 4:30 Central European time when we reconvene again. We're going to have more speakers from different countries around the world. My apologies. They wanted to take a family picture, as I'm being reminded in the chat. Okay, sure. So please join us in 2.5 hours following the same link.
Будемо раді
If
вас
you're interested,
побачити.
we're going to be happy to see you. So let us now take a family picture together.